Yes. This pretrial review is in the matter of case number CFI 030-2023 before Justice Andrew Moran. The pretrial review is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimants are represented by Hajaya Anubi, advocates and legal consultants. Lead counsel is Asha Teresa Bajoy. The defendant is represented by Lex Ensemble. Lead counsel is Mr. Santanu. Thank you, Your Honor.
Thank you very much, Alia. So, colleagues, we will go immediately to the issues that we have to deal with. But I will begin with an introduction and a recap of what has happened since I adjourned the pretrial review. As you will recall, I had become aware of the related proceedings in the detail in which they were presented in these proceedings, CFI 030. You understood, I'm sure, that I was not then in full possession of all of the details of those other cases. And I learned that the matter CFI 019 was proceeding and was at the stage of there having been the grant of a permission to bring a derivative claim in those proceedings, which was the subject of an application for permission to appeal. I indicated to you that I would familiarize myself with the other sets of proceedings and that I would discuss the matter with the Deputy Chief Justice, Justice Ali, Al-Madani, as I will refer to him. And I've had that discussion with him, and he has explained the position to me in CF 019, which is presently outstanding, or there is presently outstanding in those proceedings, the application for permission to appeal, which will be decided in due course. That may, of course, not be the end of CF 019 appeal proceedings, and certainly may not be the end of CFI 019 if that matter proceeds. Accordingly, I reviewed this claim CF 030 and CF 019, and it became apparent to me that there are discrete issues in CF 030 that may usefully, efficiently, and properly be tried in advance of CF 019. Following or seeking to achieve the overriding objective. A trial date has long been set, court time and judicial time has been set aside, and it is appropriate, it seems to me, to proceed to try the issues which I have identified in a draft order. But I tell you immediately, I have a little concern about what is issue number 4, which is taken from the case management order of the 28th of September 2023, made by His Excellency Justice Nasir Al-Nasser. And I'll mention that to you both in a moment. It's really a matter for the claimant in these proceedings that I want to deal with. So the purpose then of reconvening this pretrial review is to deal with matters leading up to the trial of the issues that I have identified, subject to any representations that any party may wish to make, in the light of what I've just told you, and in the light of what I want to discuss now in relation to issue 4, principally with the Claimants Counsel, Ms. Bedjoy, as to whether that issue, the whole of it or part of it, should properly proceed to trial on the 27th of this month. You will have appreciated that the rationale behind the ruling that I propose to make, subject to your submissions, and the order I propose to make, is that I am seeking to deal with the breaches of the alleged breaches of the MOU, whether it's binding or not, and the share transfer agreement. And those are the issues which it seems to me can be discreetly tried, and it is appropriate to try them as they arise really first in time, and depending on findings in relation to them, may explain a lot of matters which arise in CF 019, and therefore it seemed to me to be appropriate to try the issues that I have listed, subject to the issue 4 matter that concerns me, which I'll come to in a moment. You will also have observed from the draft order that the matter of CF 019, if it survives the appeal process presently underway, will be allocated to me. So I will be the managing judge, the case managing judge, and the trial judge in due course if that matter proceeds. As I say, I put it that way, if it survives the appeal process. So the concern that I had, the principal concern that I had that I explained to you, the risk of conflicting outcomes on common issues in the two proceedings, has been addressed by the definition of issues to be tried in CF 030 at the outset. I'm not, as it were, dismissing the other claims in CF 030. They are to be considered and case managed depending on the outcome of the appeal process in CF 019. So the claimants should not be concerned that I am in some way disposing of those matters. They are not being disposed of, they're just being put off to a more convenient and efficient time for determination. So that is the thinking behind the order which you have before you. It is described as a proposed order, but I find it difficult to see, now that I know what all of these cases are about, how we could deal with this matter in any more efficient and proper manner than is contemplated by this order. So that by way of introduction. And the first matter I want to deal with is issue 4, which is presently for trial in full. And just reminding you of that, if you can go to it either in the case management order from September last year or in the draft order, it is whether the transfer of 100% shares of the first defendant from the third defendant to the second defendant, that's Miss Phoebe Leah Tuka, and thereby beneficial interest. UBO, well, what's that UBO intended to mean? UBO.
Ultimate beneficial ownership, Your Honor.
Right, okay. It's
beneficial interest, it stands for basically, as per the disclosure requirements, a party has to update, or an entity has to update the shareholder.
I understand.
Yeah.
You don't need to go into it. It was just the acronym that I had not seen in use before. I've of course familiar with the phrase ultimate beneficial ownership, well familiar with it. So of the first defendant in the first claimant to a third party without the unanimous consent of the other shareholders is a violation of the memorandum of understanding and share transfer agreement. So that's the first part of it. That's a question, an issue, which you are seeking to be tried. But then there are these sub-issues, A and B. Whether the first claimant has sustained loss due to the change in beneficial ownership of the first defendant without being informed about this change by the first defendant. And secondly, whether the first, second, and third defendants are liable to pay compensation for the damage sustained by the first claimant due to the change in ownership of the first defendant, as this is a violation that, of course, is to be determined of the agreement between the parties. Now, Well, Ms. Bejoy, can you explain to me or point me to where it is pleaded that the first claimant has sustained a loss due to the change in beneficial ownership? And secondly, where is that loss evidenced or quantified? Because at the moment, I'm at a loss to understand where that claim is going to. Let me put it that way. Issue 4.
Yes, Your Honor.
I understand perfectly that it is part of your client's defense in CFO 19, justifying the defendants, as they are in those proceedings, conduct in relation to the management of the company and the exclusion, so the claimant in those proceedings contends, of the shareholders from important important aspects of corporate management. I understand that. I see that it is potentially relevant in CF019 by way of defence, part and parcel of your defence. But in CF030, you have not pleaded, as far as I can see, any particular loss, either liquidated or claimed liquidated or unliquidated damages in any part of your claim or in the witness evidence which is led in support of it.
Yes. Your Honor, before I address on this point, if I may also submit some preliminary issues that are relevant to the trial that is proposed to be conducted on the 27th of May.
Yes.
I would like to submit that I have received instructions from the solicitors that the timeline that has been stipulated by Your Honor in your draft order for amending the pleadings, or rather striking out and submitting a modified version of the pleadings along with the witness statements, according to them, would require more time, and they feel that 13th of May would be difficult, or rather would be unachievable, given the fact that because the pretrial review was adjourned, they were under the impression that the trial will get eventually pushed to another month. So they were really not prepared to make the pleading modifications. So
let me stop you there. Do forgive me, I seem to have a frog in my throat this morning.
Same with me, Your Honor. I'm also suffering.
It can't be the weather 3,000 miles apart.
Correct.
But I really need to stop you there. I made it absolutely plain that I was not vacating the trial on the 27th of May, and that I was investigating these matters that I have now investigated with a view to managing the trial on the 27th of May if it remained in place. That's the first point I want to make to you, and I'd like you to address me on to the contrary, if you can possibly maintain any position to the contrary. And secondly, the direction I have given, and I've been looking at it myself yesterday and this morning before starting, the direction I have given is for deletion only, striking out, marking up as not relevant. It is not a question, I've made it plain in the draft order, of allowing any form of amendment to supplement, modify or alter the pleaded case on the issues which I have determined, subject to your submissions, should be for trial on the 27th of May. So the exercise is really a very straightforward exercise. I've been doing it in part for my own benefit, going through these voluminous pleadings, most of which relate to CF019, the issues in CF019, and striking them through because they're not relevant. Similarly, with the evidence, there are vast tracts of the evidence which are not relevant So these breaches of the shareholder agreement, the failure to provide the gold capital that is contended for, 200 kilograms of gold. What is the effect of the shareholders' resolution of the 31st of December 2020, and of course the share transfer agreement that followed it, and so on, in relation to the obligation which is contended for, which it is said was breached, to provide 200 kilograms of gold. So what I'm seeking and directing is a very considerable slimming down of the present statement of case and the evidence to focus on the issues that are going to be for trial. So let me then ask you this question. How long do they want your instructing solicitors to strike out what is not relevant to the issues that are going to be tried? We'll talk about issue 4 rather more in a moment, but how long do they ask for before the 27th of May to simply go through the pleadings with a red or a blue pencil, whichever they choose, to strike out what is not relevant to the issues that I'm going to be trying?
Yeah, Your Honor, in that regard, I would also like to seek a clarification that, as we appreciated, the pleadings is quite voluminous. Now, if we simply do the exercise of strikeout, I am concerned that the pleadings may lack its presentation, its flow, and its natural coherence, which is essential for the strength of the case. So from that point of view, my instructing counsels are of the view that striking out could be not a very useful exercise. Rather, what they can do is they can streamline the whole process by putting in a paper without deviating from their case, but fully focusing on the issues that are currently going for trial. And that exactly is the reason why they feel 13th of May, which is next week, coming Monday, would be too short of a timeline. Rather, if they can push it to maybe 17th of May or 20th of May, the latest, then I believe, Your Honor, they might be able to, again, this is my humble submission, of course, subject to the opposite counsel's concurrence as well and Your Honor's kind indulgence on how we can address this time limitation, especially considering the fact that there is a lot of tidying up work that needs to be done on the pleadings.
It sounds to me there as though you are proposing to file a different pleading altogether.
Yes, Your Honor. In the look and feel, it will be a different pleading, but there is no deviation from the facts of the case or the claims that are going to be advanced or persuaded.
So why can you not strike out those matters in the present, particularly in your reply, for example? I'm going to say the same thing to the defendants here shortly. The vast bulk of their defense is to advance their claim in CFO 19, the vast bulk of it. In fact, paragraphs, the only directly relevant paragraphs, and I'll hear representations on this from the defendants in due course, are paragraphs 18 to 26 of the defense that actually go to the issue of the breach of the shareholders' agreement. And it's the same with the witness statements. Vast tracts of the defendant's witness statements. Indeed, they're a complete facsimile of the evidence to be led in CFO 19. And that is going to go. It's going to be struck out. Not forever, of course. It's in CFO 19. The same in your case. All your contentions about defamatory remarks and damage to the business and so forth that are contended for, that is going off for trial at an appropriate time, in conjunction with or after, depending on how things appear to me at the time, CFO 19. So I'm very concerned about your instructing solicitors' apparent intention to present a different pleading as opposed to a pleading which is filleted to advance the case that they make on issues 1, 2, and 4, insofar as we need to discuss that one further.
Yes,
So,
Your Honor. Your Honor, if I may please to address you on this point. So, Your Honor's benefit, ultimately, the pleadings are made to lead the court into this exercise of finding the truth and putting a conclusion to the dispute between the parties. So if Your Honor were to believe that striking out irrelevant or not directly related pleadings from the current version of the pleadings, and we focus only on point numbers as identified in your Honor's draft order, I would agree with Your Honor that that exercise wouldn't take much time. So, Your Honor, I could definitely take instructions from my instructing counsels in that regard. As I understand that the liberty that's given to us is only to streamline, strike out, and not to add even a single word. Considering that and keeping that in mind, Your Honor, I would definitely, if Your Honor may permit and give a small recess, maybe after we discuss on all the issues, I could then quickly take their instructions and get back to you. But in that regard, Your Honor, would it be possible to at least extend the 13th May deadline to maybe 18th? Is that a possibility?
I will hear from Mr. Santanu in a moment, but I'm dealing with these matters with you first of all. And I think we need to return to issue number 4
Yes.
before we, as it were, sign off on the form of pleading and the form of witness statements that you're going to file in accordance with my directions. So let me just try and clarify it a little bit further. Are you suggesting or seeking simply to, as it were, produce a new statement of claim which lifts out sections from the existing statement of claim without modification of the words? You said not a word will be changed, and planting those in a new document, let's call it an amended statement of claim, though it's not amended. I use the expression filleted to accord with the issues that are going to be tried. So is that what you're asking for, to actually produce a document lifting out the allegations and pleaded facts that are relevant to the issues which I am going to try on the 27th of May? Is that what you're asking for?
Yes, Your Honor.
Right.
We can submit 2 versions of the pleadings, Your Honor. We could submit a strikeout version, and we could also submit a clean version that would only have the pleadings relevant to these issues.
Well, that would be very helpful, I think. That would actually make things easier. And in fact, I will ask Mr. Santanu whether he also agrees with that, because that would be helpful in his case as well, because there's rather more to come out of his defence as it presently stands. It's all in CFI 019, and it will be determined in those proceedings if it survives the appeal process on foot. So what you're proposing is 2 documents, and indeed the first is what leads to the second. The first document will be a redacted existing statement of claim. The second document will be what is left after the redactions.
That's right, Your Honor.
Well, that seems sensible and indeed helpful to me, because once I check the redacted version against the
clean version,
the clean version, I guess let's call it the clean version. Once I do that, I can then focus on the clean version, and likewise with the witness statements. So that, I think, is a good suggestion. So really, the only subject to Mr. Santanu, the only issue is whether you should have until you're asking for the 18th of May.
Your Honor, if I may please clarify, 18th supposed to be a Saturday. So
the 20th.
We are requesting, if we can, time until 20th of May, what we can do is we can submit all of these documents together. I understand there is a requirement to submit the bundle
Skeleton.
also by 15th of May.
Yes.
So if we be kindly permitted to submit the trial bundle along with all the revisions on the 20th of May, this is our humble submission and a prayer, Your Honor.
I see. And then you'd want the skeleton arguments put back a couple of days so that you can make references to the bundle in its present form.
Yes, Your Honor.
It should seem sensible. Well, shall we deal? It's really your preference, Mr. Santanu. I'm prepared to hear you now on that procedural proposal, or it might be better to hear from the claimant in response to my observations about issue 4 before I hear you, Mr. Santanu, on everything. So let me come back to issue 4, Ms. Bejoy, so we know where we're going.
Yes, Your Honor. So, Your Honor, if I may please address you on the issue number 4.
Yes.
Basically, issue number 4 evolved because of the bulky defense that has been put in place. Most of it has relevance to 019 and the derivative pleadings.
Yes.
And because this was most of the part of the defense, we ended up having this as an issue to be resolved because we had discussions in the case management conference wherein there was requirement from the opposite party, from the defendant, also to have additional issues to be sorted out. And that, I believe, is the reason why we have issue number 4 included in the list of issues to be sorted out in this particular claim.
Yes.
Also, Your Honor, now that we are deciding to carve out any issue that are relevant to 019, it is my humble submission that issue number 4 can also be dealt with subsequently along with the other segregated or carved out issues.
Yeah, well, that's why I've raised it with you, because that appeared to me to be more appropriate. The reason why I left it in is because the claim is based on the alleged violation of the Memorandum of Understanding and the share transfer agreement. So I left it in for this discussion we're having now, but really it does seem to me, and you seem to confirm that, and I will let Mr. Santanu obviously make his comments on this, that this is all part and parcel of CFO 19 if it proceeds, because this failure, which you say is a breach of the Memorandum of Understanding and Share Transfer Agreement, to first of all, the actual transfer to the shares, the beneficial ownership to Ms. Tucker, this all goes to the defendant's conduct in CFO 19, the defendants as they are in CFO 19. It all goes to their conduct in their management of the business and the actions that they took, which are challenged, complained about, sought to be rectified in CFO 19. That seems right to me. So I will hear from Mr. Santanu on that, but it does seem to me as if issue 4 is better tried with CFO 19.
Your Honor, before, can I also interfere?
Yes,
just to make a small submission. Also, Your Honor, issue number 4 is directly related to or has a bearing on issue number 3, the original issue number 3 on the defamatory claim.
Yes.
So since issue number 3 is being taken out, ideally issue number 4 also should be dealt with together because these are directly correlated.
Yes, I can see that too. It seems to me it's all part and parcel of CFO 19 and
yes,
and the defamation claim. One is a mirror of the other, and that is now abundantly clear to me, having been able to study CFO 19 and, as I say, speak to the Deputy Chief Justice, who obviously has a much greater knowledge of CFO 19 than I do at this stage. So, right, is there anything else you want to say on these issues we've been discussing before I hear from Mr. Santanu to see whether he agrees with the approach to the pleadings and the witness statements that you've now outlined? So that is a redacted version and a clean version for summary's sake. And then the second point, that we actually adjourn off issue 4 for further case management after the appeals process is complete in CFO 19.
Yes.
So I'll turn to Mr. Santanu unless you have anything else to say on those issues, Ms. Bejoy.
No, Your Honor, I'm grateful. Thank you.
Right. And I can tell you that I am minded to give you more time that you're asking for, subject to anything Mr. Santanu says, but he's going to get that time as well to do what he needs to do. So perhaps my initial reaction about simply striking out has been improved on by what you're suggesting, that we have a redacted and a clean version. So, Mr. Santanu, what do you say about redaction and clean version of pleadings and witness statements?
Yeah, I have no objection to that. We should do that, and that should be the process. Initially, when I went through this proposed draft order, which was sent by Your Honor, and it says that on the 13th of this month, both of us should file the deleted portion. So, which I was a bit concerned because I wouldn't know what are the portions which they are deleting unless we sit together and do it. So yes, I have no objection if the date gets changed to 20th, and I'll need 5 more days at least, or by the end of that week, to file the written submissions to those, the written statement. And thereafter, so in that case, the trial dates might also change. You
need time to...
I don't know whether any new pleadings will be pleaded in the submissions, or that's something which I'm not sure of until and unless we see the document. But if we are submitting together on the same date, I mean, either I will miss out something or she might, Miss Asha might miss out something. So we don't know that unless we collaborate before that and discuss and exchange the pleadings and with written statements, written objections, and then submit it on the 20th together.
Well, I'm not contemplating adjourning the trial date. Time has been set aside in the court, judicial time has been set aside, and the matter will proceed to trial on the 27th of May in its restricted form in accordance with this order, whether it's just issues 1, 2, and 6, and leaving out issue 4. I'll come to that in a minute. It will proceed on that date. The second point, Mr. Santanu, is that what we're talking about here is each party striking out or redacting, let's use that word now, redacting their existing pleading. It is not going to be necessary for there to be an exchange of redacted pleadings. If a party contends at the trial that something remains that should have been redacted and is in the clean version, which is not relevant, then the court will make an assessment of whether it is relevant to the issue or not. This is not a case of you having to respond. This is a case of exchanging a manifestation of your case restricted to the issues now to be tried. So there is no question of an exchange here. Of course you'll exchange, but there's no question of a responsive pleading. You can contend at trial that something which is in the clean version has not been redacted is irrelevant, and I will hear and determine those submissions. But it should be clear to you both that what the court is seeking is an efficient, streamlined process. You've said it yourself, Ms. Bijou, I'm borrowing your words there. so that we can focus on these issues that are going to trial. And if either of you includes something that should have been redacted, the other may object at trial, and I will weigh it and consider it and determine whether it's relevant or not, in the same way that at trial one always considers what is relevant and what effect it has in the determination of the issues for trial. But it really is for both of you to strive for efficiency, to cut out what is irrelevant because it's part of CF019, and to focus on the definition of issues that you've agreed. You agreed them. All I'm doing is refining them or moving them for trial. And that is, it seems to me, the way you should approach this task. So we will simply have a filing of the redacted and clean versions on a date to be ordered by me. It's looking like the 20th of May you're contending for at the moment, both of you. And then you file your skeleton submissions on a date between the 20th of May and the 27th of May, when the trial starts, to give me enough time to consider your submissions in advance. That is really the bottom line, plain and simple. What do you say, Mr. Santanu? Are you content with that approach?
Yes, I accept. I mean, we have an opportunity in case something which should have been redacted is not redacted. Of course, during the trial, your lordship will consider that.
Yes. I will.
So, yes. So I accept then. We'll do it on the 20th of this month.
Yes, and that's cuts both ways, sauce for the goose, sauce for the gander. Yes. You can each make a submission if something has not been redacted that you say should have been redacted. And then you can persuade me as to its relevance or not. And that I will hear from you on that in either opening or closing or at an appropriate time. Yes. And the same may arise in relation to witness evidence as well. You may contend that matters should have been redacted that have not been redacted, and so forth. So that's another issue I want to raise with you about witness statements, but let's just talk for the moment about the timing of this. So if I give you till the 20th of May, which is a Monday, is it, Miss Bejour? I have not got my diary open.
Yes, Your Honour, 20th is a Monday.
Right, and the trial starts the following Monday, the 27th.
That's right, Your Honour.
So when do you want to file your skeletons? The reason why I have got staggered filings, 20th and 21st of May in this draft order, is because that is what you agreed originally. Although the case management order was a little bit confusing in this respect. And that's why I clarified it. Paragraph 31 of the case management order, I found somewhat confusing. Let me just turn that up. Well, I don't really need to. Yes, what was written was skeleton arguments and written opening statements shall be filed and served 2 clear days before the start of the trial for the claimant, and in any event by no later than 4 p.m. on the 20th of May. That doesn't make sense. You see what I mean? So yes. That's what I was trying to rectify with my clarification. But what I was loyal to in my proposed order was your agreement, which I think is helpful, that there should be a sequential exchange. So the claimant goes first, and 24 hours later, the respondent responds with its skeleton. Now, I appreciate you'll be preparing your skeletons independently, but it allows for any focused response to any particular issue that's not been covered by the respondent, or the defendants, in their skeleton argument being prepared up to that date. So we've got a span there from Monday the 20th of May to the 27th of May, and I'll start with you, Miss Bejoy. When allowing for 24 hours for the respondent to file its skeleton, when do you wish to file your skeleton argument?
Your Honor, I'm looking at the diary now. So 20th being a Monday, I'm thinking, can we take up to maybe 23rd, Thursday, for submission of the skeleton? Considering the fact that the defendant will be making their skeleton on the 24th, which is a Friday, that leaves Your Honor with the weekend, that is 25th and the 26th, to go through and be prepared for the trial that commences on the 27th.
Of course, I always work weekends. There's no question. It's just the presumption that's amusing that all judges do work weekends. It is a fact.
I'm aware of that, Your Honor. I mean, in fact, judges work 24/7. Looking at the way the matters are being dealt with. But I'm just, concerned that would it be causing any inconvenience? Would it be too much to, request this court to?
No, it's not an inconvenience, and don't trouble about it at all. I'm just having a little lightheartedness. We have, our task is difficult enough when we actually get down to fighting these cases and deciding them, so we can enjoy this little banter about judges' workload. Yes, no difficulty. I am content for you to file your skeleton argument on the 23rd, and Mr. Santonu close of business on the 24th. He's got all week from the 20th, when he'll have the bundles and the redacted versions, and an extra day to respond to matters that he's not covered in his work up to the 23rd. There's an extra day. And I do see why you agreed that in the first place. It's just that in the expression of it in paragraph 31 of the original case management order, it went a little bit awry in its expression. So I will amend. Let's just go back to the draft now. So we're getting the date of the 20th of May inserted. Paragraph 5 is the 20th of May. Correct?
Yes, Your
Honor. Paragraph 6, the hearing bundle. You've said you will do that also on the 20th of May.
Yes.
Obviously, you'll have to add to it the defendant's redacted and clean versions. I'm wondering, should we say the 21st of May for the bundle? You're going to be filleting the documents in this bundle because vast reams of them are not relevant to these issues that we're now trying. A lot of them go to CF 019 issues. So the bundle is going to be substantially reduced in terms of the documents that are filed. I'm just concerned that there is a filing by the defendants now scheduled for the 20th of May under paragraph 5 of my draft order. And the documents that it files, which will be pleadings and witness statements, will be have to be added to the bundle. So to have the same date, the 20th, it won't work, will it?
It should. I mean, it's just filing the trial bundle.
Should we say the 21st, Ms. Bejoy?
Yes, Your Honor. Yes. I think one day after submission of the documentation, in case if there is any last minute hiccups, because of course, at the end of the day, we need to agree on the documents that we are going to rely. I believe, yes, Your Honor, that is also a consensual exercise that we have to do.
Well, it is, and you should be doing that certainly before the 20th of May. You can work on that because this exercise of redacting pleadings and witness statements will produce a removal, let me put it that way, a removal of references to documents which are presently in this massive bundle of 2,000, however many hundred pages. That is going to be cut down quite dramatically for this trial. So you need to be working on that, both of you, as you're preparing your pleadings and statements redacted for service on the 20th of May now. You will at the same time be making a list of documents which need to be referred to, are referred to in the bits of pleading and bits of statements left, and that will form the bundle. So the only thing really that needs to be added to that bundle are the filings on the 20th of May, the redacted pleadings and redacted statements going to the issues we're trying. Does that make sense to you both?
Yes, yes, Your Honor.
Yes.
All right. So I will, the date in paragraph 6 of my draft order then will be the 21st.
Yes, Your Honor.
Of May. And then that gives you still until Thursday for your skeleton argument. Close of business 23rd. So paragraph 31 is hereby clarified. I'm looking at paragraph 7 now. By not later than 4 p.m. GST on 23rd May 2024, and the defendant shall file their skeleton argument by 4 p.m. on 24th May. Right. So, now the matters I want to carry on to raise with you, let me just ask you first of all, is there anything else, Ms. Bejoy, that is on your agenda that you wish to raise beyond the matters that we've discussed so far?
Before I go to any new agenda, Your Honor, I just need a simple clarification regarding the amendment to the pleadings. We talked about statement of claim, the particulars of claim and defense. Are we also having the liberty to modify the reply? Because there is, in fact, a reply on record. So shall we do that exercise on the reply as well?
Yes, I had included that in the pleadings because there's more going to come out of your reply, which deals very substantially with the CFO 19 claim, which is the defence substantially, apart from those paragraphs that I identified, 18 to 26 in the defence. So the reply will be very substantially redacted. The same applies to the reply as applies to the claim, statement of claim, and the defence. And indeed, that should be a straightforward task, because you, Ms. Bejoy, will be able to anticipate what Mr. Santanu is going to redact from his defence, because you really only need to look at CFO 19, the pleading in CFO 19, and see what of that has been lifted into the defence in CFO 30, and you will be confident that it's not. Yeah. It's going to be redacted. What will be left in Mr. Santanu's defence, redacted defence, is only what goes to these issues 1 and 2. And I think 4, I think we're agreed, 4 is going to go off for case management and trial.
Yes.
As appropriate when the appeals process on CFO 19 is complete. So is that the only clarification you were seeking, Ms. Bejoy?
Yes, Your Honor.
Right.
Grateful, thank you.
Mr. Santanu, before I deal with the other matters that I wish to deal with, is there anything else you want to raise specifically?
No, nothing. Just issue number 4. I agree with Your Honor, and that it can be sent back to CFI 019. I mean, it's part of CFI 019.
Right. Well, it will be. I will modify the order so that the trial of issues. This is paragraph 2 of the draft order. the trial of issues numbered 3, 4, 5, and 7 in the CMO shall not take place at the hearing on the 27th of May, but be adjourned to be case managed to trial in an appropriate manner, depending on the outcome of the appeals process. So 4 is now with 3, 5, and 7. And there's a
Yes.
corresponding deletion in paragraph 4, where paragraph 1, where item 6, liability of first, second, and third defendants to compensate the first, second, and third claimants for the loss in 1 and 2. 4 is deleted from that, will be deleted from that. Okay?
Yes, Your Honor.
Right, now I have some other matters I want to raise with you both. You might have the timetable to hand. First of all, I'm grateful for your efforts, your combined efforts to agree this. And what I'm about to say about its contents and the approach in it, reflected in it, does not detract one iota from the court's appreciation of your efforts to agree a timetable of such depth and detail so that I can map out the trial process. So please be assured that I am grateful to you for those efforts. But
thank you, Your Honor.
But there are a number of matters in it that concern me. Can I ask you to have in mind, first of all, the RDC Part 29 regarding witness statements. Now, let me take you to the first bit that's concerning me. Look at 2942. I'll read it out for you. Where a witness is called to give oral evidence under Rule 29.41, his witness statement shall stand as his evidence in chief unless the court orders otherwise. Okay? Now, so far as I'm aware, there is no order otherwise. So, prima facie, the witnesses will simply be called. They will verify their redacted witness statement, and they will then be cross-examined. That is the procedure that is contemplated under the rules and under the case management orders that have been made so far. But in your agreed timetable, you have provided varying lengths of time for what appears to me to be oral evidence in chief. So going through it, you've got item 3, testimony of Mr. Sami. May I refer to him for present purposes just as Mr. Sami? Mr. Sami, for nearly half an hour. That is not provided for either in any case management order or under the rules. What he has to say on these issues is in his witness statement. And then he'll be cross-examined, and then he'll be re-examined. So you will have every opportunity to elicit from him his further responses to anything that has been challenged, raised in cross-examination in the ordinary way. So can I ask, and the same is true going through all of the witnesses here, you've provided for a period, varying periods it seems, for oral examination in chief. That is not the way we try cases in the DIFC, or indeed in most common law jurisdictions now, where the evidence in chief is contained in the witness statement. Then there's cross-examination and re-examination. So there is, however, 2944, a witness giving oral evidence at trial may, with the permission of the court, amplify his witness statement and give evidence in relation to new matters which have arisen since the witness statement was served on other parties. And the court, this is 2045, will give permission only if it considers there's good reason not to confine the evidence to the witness to the contents of his witness statement. So it seems to me that whilst there's much else in the witness statements beyond the issues that we're now trying, which is going to be removed, the witnesses have set out their position on these two issues that are for trial, and that should be it. There doesn't seem to me to be any need for any oral examination in chief.
May I, Your Honor?
Yes, please do. Yeah. Tell me why you want half an hour or whatever it is in each case for oral examination in chief.
Your Honor, the only reason why we allocated some time for the examination in chief or a witness testimony is anticipating any scenario where if we may have to provide some clarification, some errors in the witness statement which needs to be rectified. So it is only keeping in mind these aspects that we have, as Your Honor can see, this is a relatively short time. It is only a maximum of 30 minutes. It may well be a shorter one, which gets entered in 5 minutes or 10 minutes, basically just to validate the document, verify his signature. And that was the purpose in mind when we allocated the time. Very
well. Well, I think you've been generous, but on that understanding, I'll leave the timetable as you've put it, and we can have then probably some spare time in case cross-examination runs on a little bit longer than you've provided for here. That's not an encouragement, by the way. I've said I commend you for trying to define these periods, and I stick with that. So as long as that's understood, then that the witness statement shall stand as evidence in chief, subject to those very limited exceptions, which if there's anything you need to correct or amplify, I will hear you at the trial and make my decision as to what latitude to give you.
Much pleasure.
Okay, that's the first thing. Just one matter that leapt out to me. This is a matter for you, Mr. Santanu. The statement of Mahmoud Rostom Fakhran, I hope I pronounced that correctly, paragraph 17, which is at page 1827 of a bundle I have. I don't know whether these page numbers correspond to the bundles you're working from. Not in that one. I'll go to his statement. So if you go to the statement of it's tab 5 or divider 5. The red page number is 1822 on top of it. And if you go to page 17, paragraph 17, I'm sorry. He makes this allegation, which I mean, this, first of all, paragraph 17 is likely to be the subject of a redaction. I don't see any connection with this contention. But the defendant number 2, I think that must be defendant number 2 in CFO 19. That's not defendant number 2, Phoebe Tuka. Mr. Fakhran is not suggesting that.
Yes, that's a mistake. That's
a mistake. Yeah, I thought it was a mistake.
Yeah.
So I mean, I've drawn it to your attention, but there's a good example of something which is irrelevant to the issues that we're going to be trying. So that will come out. I'm not going to go through this. You know very well what needs to come out now, but there's a good example of something that will come out. And then my final requirement, and I don't think it's in the order, the draft order. Check. Yeah, it's not. I'm going to add it to paragraph 6 of the draft order about the bundle. It's absolutely critical for my easy navigation of the bundle. I don't know how big it's going to be, but it's going to be much smaller than the existing bundle of thousands of pages. I need an index. I need an index. Critically need an index. In bearing in mind the limited time, I mentioned this just for future reference when you're preparing bundles, PDF bundles. You won't have time to do this, but I do mention it because it's speeds things so massively. If you have an index and you hyperlink, not bookmark, hyperlink the item in the index at the front to the document which is being referred to. I click on it, bang, I'm at the document faster than I can blink. That is what is being done in modern litigation practice and in arbitrations as well all the time. The use of hyperlinks. It's so much more speedy. With an electronic bundle, as long as I have an index, there will be a page number. I need page numbers, not just tabs, page numbers. And the electronic page number must correspond to the hard copy page number. So I can get by without the hyperlinks in this case, as long as the page numbers, electronic page numbers in the bundle correspond to the hard copy bundle page numbers. I will go into my software, my document reading software, I insert the page number, and it's almost as quick as a hyperlink, but not quite. So for future reference, I'll give you that plea to use hyperlinks.
Yes.
For the time being, I'll be content with a properly paginated, reduced electronic bundle to be filed on the 21st of May, as we have discussed and agreed. Right, that is everything I wish to raise with you. Is there anything further that you wish to raise with me in advance of the trial?
No, nothing from my side.
Thank you very much, Mr. Santanu.
Same with me also, Your Honor. Thank you.
Right, good. Well, thank you both very much indeed. I look forward to receiving your skeleton arguments and my joyous weekend to come, and seeing you on the 27th of May for the trial.
Thank you.
Much a pleasure.
Thank you very much.
Much obliged.
Good day to you both.